In the know.
Good evening, everyone.
In the know.
Tony Reeves, fire. Following the news in any way, shape, or form. No shortage of things to talk about. What does it mean? What will it bring? Is this a reality we simply have to accept? Tony Reeves, fire. Tony Reeves. Let's go ahead.
You got approved at the hearing. Woohoo! And why do you still have to wait? Okay. This pops up a lot. You go to the hearing, and under the rare circumstances, you get a judge that's nice enough to say, I think you're disabled. And you're thinking, ooh, at a time. All right. Two things you need to realize. First of all, you want the written decision. Why? Because you want to know the basis by which the judge found you disabled. You want to know what medical evidence they relied upon. You want to know when they determined your disability began, what conditions and what your specific limitations. You want all that in writing. Now, let's be real here. You really only just want the money at this particular point. The money and the medication. Excuse me. The money and the medical insurance. Those are usually your two big things. All the rest of this, you're like, yeah. Money and the medical insurance. That's beautiful. But really, you need the written statement because this is what you need in order for you to get approved and for you to get paid. Now, it's only final until you get a written decision. So the reality is that I know some of you right now are sitting there freaking going, oh my God, does that mean that the judge could change their mind? I hate to be the bearer of bad news. Absolutely. I've seen it, and it can happen. So the reality is that it's reassuring to know that the judge is telling you what direction they're going. More importantly, it's reassuring because a lot of times they put that on the record. So you have it on the record that they have conceded they're going to basically find in your favor. So you want to make sure that you get that written decision. Now, we come back. We're going to talk a little bit more about why it's important that you have this.
Under the Social Security regulations, representatives are permitted to practice before the administrative agency anywhere in the country, which means that when you're looking for a representative, you can find someone who doesn't necessarily have to be in your state if you're just going before the administrative agency. So it's possible to have an attorney or representative who's from Utah, even though you may be in Georgia. And our office is actually no different. So if you're wondering which states we cover, check this out. Now, the tricky part is once you have to sue the Social Security Administration. Under that situation, you want to have an attorney that's representing you in your jurisdiction. So if you have a representative who's in another state and you've gone all the way to the Appeals Council and you've been denied and you want to sue the Social Security Administration, make sure you ask that representative whether or not they can sue someone in that particular state.
All right. Party time. You had a hearing. The judge told you at the hearing you're approved. You're freaking out because now I've said a few things that's caused you pause because I've told you don't get too comfortable until you get the written decision. Let me tell you why you need that decision. One, that's how you get paid. That's how you get your insurance if you're entitled to receive it. That's how you get your back pay. That's how you get your monthly benefits. That document is what gets you paid because that document is what tells the local office and the payment centers what information they need to make sure you get your insurance and to make sure you get your money. Without that, they can't do that. So it's not like the judge is going to get on the phone and call all these people up and say, yo, hook my boy up, you know what I'm saying? They need these written documents in order for this to happen, okay? Also, you need it in the event that the judge gets wonky and does something in your decision that really wasn't proper and you want to appeal it. You got to know what the judge's final decision was so that now you know specifically what you need to look at for purposes of appeal. So, am I telling you when the judge tells you at the hearing you're approved that you should freak out and think that he's not going to approve you or she's not going to approve you? That's not what I'm saying. Is it possible? Absolutely. Anything's possible. But it's important for you to know that in order for you to get your benefits and for you to get your insurance and whatever happens in terms of your back pay and your front pay, however it lays out, you need the written decision in order for these things to happen. Trust me, in the grander scheme of things, you need the written decision.
I want to thank all of you for engaging in the videos. Make sure you take the opportunity to send me any comments or send me any particular questions that you want me to have addressed here. As you know, this show is for you, and so the only way I can make sure that I can provide you some good information is if you provide me some good questions. Keep them coming, and right here on Q&A, Social Security Disability Today.